What do you make of, the case?
Well, I mean, each case turns on its own set of circumstances. I mean, we had to make decisions in this case based on consultations in the office. We had to make decisions based on the evidence, decisions based on who the witnesses are. So at the end of the day, the collaborative effort inside the office and our case file preparation led us to, one, accept the manslaughter plea and to put ourselves in a position to address the court and sentencing. So, I mean, at the end of the day, what we are saying is that justice is
20 years, 10 months. How close to justice for the family do you think the court took that?
Justice.
Justice, I agree.
Justice. The offense was manslaughter, and we got 20 years and 10 months. For murder, sometimes the sentence is just that, 20 years or even less. So, justice.
You feel 20 years, 10 months kind of take the public off your back, as it were, because a lot of people in the public were saying...
I never felt like the public was on my back. My position is this. Most persons, when they hear manslaughter, they think of a motor vehicle accident and somebody has died. So education is what was required, is what is required. So I didn't feel as if the public was on my back at all. And I knew that when we got into court, and certainly when you were allowed into court, you would hear more. But no, I've never felt like the public was on my back.
What's some of the biggest misconceptions when you listen to that video?
Biggest misconceptions? Well, I don't know what it is that has been said out there much, I'm not on social media. I'm not listening to that. Well, we have a file and we read and prepare the file. We look at the law. And this decision was made based on law. That's it.
The public felt that the prosecution could have tried to, fight this case and probably win.
But what do you mean by fight, though? Because that's exactly what we did. We made a decision. And so I want the public to appreciate that when you talk about going to a trial, you're talking about getting witnesses to come to court, to go into the witness box, and hopefully that they will say what it is they said in a statement some time ago, almost verbatim. We're talking about where this particular case is concerned, putting two little boys in the witness box to speak about what it is they're saying daddy did in respect of mommy. That is something that needs to be taken into consideration as well. So we look at the law, we look at the material we have, we look at getting the witnesses to come to court and basically for them to be consistent in terms of what they've said in their written statements. I think we made the right decision today. Where the law is concerned, where the statement that the accused man gave is concerned, it was glaringly obvious that he had the partial defense of provocation.